Welcome my fellow tax professionals. In this video, we're going to be discussing the IRS's decision to accept the offer and compromise application. I'm your host, Attorney Robert Schaller, and the author of this course. The IRS's decision to accept the offer and compromise application typically relates to the amount of the IRS's reasonable collection potential. An offer amount in Form 656 that equal or exceeds the reasonable collection potential of the IRS will be accepted by the IRS, assuming the taxpayer satisfies all other responsibilities. However, the IRS will not accept an offer and compromise application if the amount in Form 656 does not exceed or equal the reasonable collection potential. So therefore, again, it's critical that the tax professional understand how to calculate the reasonable collection potential. Enjoy the video. Let us begin exploring the IRS's analysis behind accepting the pending offer and compromise application. The decision whether to accept an offer to compromise is within the IRS's discretion and must be based upon consideration of all the facts and circumstances. In keeping with an IRS policy statement, an offer will only be accepted if it is determined to be in the best interest of both the taxpayer and the IRS. The IRS may take into account public policy and tax administration concerns in determining whether an offer to compromise is acceptable. So let's explore the IRS's acceptance policy. The IRS will accept an offer and compromise when it is unlikely that the tax liability can be collected in full prior to the collection statute expiration date, and the Form 656 offer amount exceeds the IRS's reasonable collection potential. An offer in compromise is a legitimate alternative to declaring a case currently not collectible or to a protracted installment agreement. The IRS's goal is to achieve collection of what is potentially collectible at the earliest possible time and at the least cost to the government. Thankfully, Congress introduced a fail-safe protection policy to safeguard against a protracted IRS review. An offer shall be deemed accepted automatically if the offer is not rejected by the IRS within 24 months from the date the offer was submitted. However, an offer will not be deemed accepted if the offer was, within the same 24-month period, rejected by the IRS, withdrawn by the taxpayer, or deemed withdrawn by the IRS, or returned by the IRS to the taxpayer as unprocessable or no longer processable. Acceptance of the offer to compromise conclusively settles all liability issued for the periods covered by the offer. That includes total tax liability, penalties, and interest. Acceptance of an offer to compromise will conclusively settle the liability of the taxpayer specified in the offer once all the terms and conditions of the offer have been fully satisfied. Thank you for listening to this video, and please spread the word to your fellow tax professionals. The National Offer and Compromise Academy is available to help professionals expand their practice into the profitable area of offer and compromise. The music for this video was provided by www.bensound.com. You can contact the Academy from its contact page at www.oicacademy.com. Enjoy the online course and keep on learning.